Something that sounds simple, but people have difficulty understanding it, is that when you create a living trust, that is a legal entity that's completely separate from you. That's why it works. That's why probate is voided, is because that asset didn't belong to you when you died, because if it belongs to you, it's got to go through probate. But if it belongs to your trust and you pass away, the owner didn't die. The owner is your trust. Now, here's the thing. Assets don't magically become owned by somebody's trust. Just because you created trust, things don't automatically belong to it any more than if I tell my child, I'm going to make you the owner of my house. If I don't go and do a deed giving them ownership, they don't own it. There has to be something that transfers the assets into the trust once you create it, or the value of the trust goes away. Now, with most attorneys, when they create the trust, if the client owns property, they will make sure that the real property is transferred into the trust. Now, I've seen instances where attorneys did not do this. They left it up to the client to do the deed, and I think that that's a bad mistake. But in almost all cases, if you're dealing with a reputable estate planning attorney, they will make sure that your real property gets transferred into the trust. But the attorney doesn't have authority to transfer bank accounts into the trust, or if you have a stock account, the attorney can't do that for you. Those are steps that you have to take yourself. The other thing would be, a few years down the road, you decide you're going to sell your home that's currently in the trust. You have to make sure that the new home that you buy is what we call titled in the trust, so that it doesn't show up with just your name on the deed. It shows your trust on the deed so that the trust will own it. You can buy and sell property hundreds of times, and as long as you have a new deed that shows the trust as the owner, you don't have to go back and change the trust. The trust owns it if the deed says it belongs to the trust.